everything will be the same for foreign employees. You need to give them the same rights as you give a local employee. My name is Liaw. I'm an employment lawyer and a principal at Liaw Chambers. Under the Employment Act 1955, it clearly says that foreign employees or foreign workers are considered employees under the Employment Act. So just because they are a foreigner, just because they are not Malaysian citizens, that does not make them not an employee in the eyes of the Employment Act. They are still treated as an employee and they are still protected by the Employment Act. The Employment Act just defines a foreign employee as an employee who is not a citizen. So when there are sections that specifically talk about rules and regulations relating to foreign employees, they are referring to these people. As long as they are an employee of yours and he is not a citizen of Malaysia, then he is a foreign employee and is governed by those specific sections. But what is important for you to understand is that a foreign employee is entitled to the same protection as a local employee, and those protections under the Employment Act. Of course, there are some sections which says that there will be a slightly preferential treatment to local employees over foreign employees. For example, when it comes to termination of employees due to redundancy in a retrenchment situation, the laws make it very clear that if you can terminate first, you should terminate the foreign workers first, not a termination of the local employees first. So there's a preferential treatment to local employees. But in general, all foreign employees are entitled to the same rights and protections as a local employee. So that is the most important thing you need to understand. So that automatically means that every right that you see in the Employment Act, and when it comes to overtime pay, rest day pay, maternity leave, holiday pay, everything will be the same for foreign employees. You need to give them the same rights as you give a local employee.